in this ruling. Consequently, the following orders are hereby issued. 1. The applications for conservatory orders are hereby disallowed. 2. The conservatory orders issued on 18th of October 2024 in Keregoya High Court E015/2024 are hereby discharged and or set aside. Costs of these applications shall be in course. We grant leave for appeal, type proceedings, and certified copies of this ruling to be availed to parties at cost or as it may be. We will mention this matter on 7th of November 2024 at 2 p.m. in the open court. This ruling shall forthwith be uploaded in the court tracking system. That is the ruling of the court.
My Lord, do we want to take this opportunity to thank your lordships for the time that you have taken and the judiciousness with which you have expedited the applications. And I also want to thank my colleagues from the respondent side and from the applicant side for the maturity with which this matter has been handled. We are most grateful, my Lord.
Thank you. My Lord, my name is Rachel Dudley for the Deputy President, and I wish to make an application. The application I wish to make is called the Madhu Paper Injunction. Madhu Paper International, quite a famous case. In the common law, it's called the Erin-Ford Injunction. My Lord, the Madhu Paper Injunction operates on quite a simple premise, the premise of human vulnerability. In the case of Erin-Ford, where that injunction originates, Justice Megal, after dismissing an application for injunction like you have now, found still that there could be the slightest chance that he was wrong. Here, there could be the slightest chance that you're wrong. Last week, this court gave the Deputy President leave to appeal. We thank the court for that generosity. The Deputy President has appealed. He also has pending before the Court of Appeal an application for stay of these proceedings. And that application comes up on the 6th of November 2024. My Lord, operating on the premise of human vulnerability, the foundation of the Erin-Ford or Madhu Paper Injunction, we request you to recognize that you could be wrong. And if you're wrong, then the pending proceedings before the Court of Appeal would be rendered nugatory. To avoid that possibility, the possibility that the Deputy President's right to appeal, which you recognized and affirmed and upheld by giving him leave to appeal, even where he needed none, we ask you to issue a Madhu Paper Injunction. We do not seek an indefinite injunction. We seek an injunction until 6th of November 2024, when we are next before the Court of Appeal. Thank you, my Lord.
We also have a moment by the chair. Yeah. My Lords, I want to associate myself with the submissions made by my learned friend, and also state that I have listened keenly to the ruling that has been delivered by this honorable court. While we largely disagree with it and we have a right of appeal, Your Lordship, it is imperative for us to know or to assess how that office of the Deputy President will be filled. This court has affirmed its commitment to observe the rule of law and protect the Constitution as decreed under Article 3 of the Constitution. It follows, therefore, Your Lordship, my ladies, that the filling of that vacancy must flow or must follow the Constitution. And as such, Your Lordship, and as much as I have not heard the court address that very pertinent issue, it is my submission, Your Lordship, that I rise under Rule 23. Beg your pardon. Rule 23 and Rule 24 of the Mutunga Rules. And I make an application, Your Lordship, that pending the determination of this application, done under Rule 24, that this Honorable Court does issue conservatory orders suspending the swearing in of Professor Kithure Kindiki on the following grounds. Your Lordship, Article 10 of this Constitution, of the Constitution, bids this Honorable Court to observe the rule of law. It further calls upon this Honorable Court to commit itself to ensure that there is good governance, there is accountability and transparency in the manner in which matters are done or functions are executed.
My Lord, with your kind permission,
It's an application.
Mr. Jero has referred to an application for which is seeking some orders pending, but we haven't seen any application.
Yes, Your Lordship, if Mr. Kamoso was keen to read the rules, the Mutunga rules allows me to move you informally. And subsequent to me making an application informally, the court is called upon to reduce the same into a formal application. And that, Your Lordship, I want to draw his attention to Rule 24, Sub-Rule 1. An application under Rule 23 may be made by way of notice of motion or by an informal document. Your Lordship, permit me to proceed with the grounds of my application. It is clear, Lordship, that the court...
If I may, I respect my Yes, I respect Mr. Njiru. He's referring to an application that is non-existent. Either is referring to E554. So I'm going to sit down. E554 of 2024, which is before the Court of Appeal, if you are referring to that application. But my Lord, if my friend is referring to the exercise of this court of a epistolary jurisdiction, then he should say so. But he cannot refer to the exercise of that jurisdiction, my Lord, when this court is functus officio. You have rendered yourself on the question of the application. And therefore, they cannot urge an application unless they say, my Lord, number one, is either served on us, or two, my Lord, because there's already an application for stay under Section 5(2)B of the Appellate Institutions Act before the Court of Appeal that is live and that has a date. This court would not have jurisdiction to entertain any other application for stay. They tried making an application for the Court of Appeal this morning using the same issues, my Lord, and the Court of Appeal rejected the application. They were told to serve everyone else. So, my Lord, for my friend to come here and to seek to apply for stay again, having a second bite at the cherry, is dishonest, my Lord. It's dishonest. That before the Court of Appeal.
May I suggest, Professor General, that could be your response to the application which will be made by Ndegwa?
Yes, if there's an application.
Yeah. Thank you, Your Lordship. Your Lordship, permit me to move on with my application, and I ask Professor Ogenda to have a look at the rules that I have just referred to. That, Your Lordship, you be kind enough to interrogate the circumstances under which that office shall be filled. Your Lordship, it is on record, and I invite the court to take judicial notice, that there is a clear non-existence of a crucial state organ that is supposed to oversee the processes of filling of that office in the name of the Independent Electoral and Boundary Commission. Your Lordship, the Independent and Boundary Commission is created under Article 88 of the Constitution, and the functions are created therein. One of the functions, my lady, is to maintain a voters register, is to register voters. Under Article 99, Your Lordship, of the Constitution, as read together with Article 137, creates the qualifications upon which the President or the Deputy President must attain if one is to hold office. My ladies, my lord, it is clear that the functions created under Article 99 of the Constitution can only be executed and or implemented by the Independent Electoral and Boundary Commission. It goes without saying, my ladies, my lords, that a deputy president designated or nominated must attain those qualifications. That is to mean, my ladies, my lord, that there must be an organ that will give a clean bill of health to say or to suggest that Professor Kithure Kindiki attains these qualifications. My lords, my ladies, I refer to the memorandum that was sent to the Speaker of the National Assembly by the President of the Republic of Kenya, dated the 18th of October 2024. In that memorandum, Your Lordship, the President drew the attention of the Speaker to the clearance of the designated candidate by the IBC. And this is what the President had to say. Your Lordship, the President indicated that he has had confirmation that Professor Kithure Kindiki meets and attains the qualifications created under Article 99 as read together with Article 113 of the Constitution. My ladies, my lords, when the President of the Republic referred to the IEBC, and I call upon the court to take judicial notice of that document, it was a presumption that that confirmation was done by the Electoral and Boundary Commission as created by the Constitution. My ladies, my lords, it's my humble appeal that this honorable court does fight in my favor to issue the conservatory order on the basis that there is no clearance that has been issued by the IBC. We all know, my ladies, my lords.
My lord, may I just seek your guidance? When Mr. Giro started off, we thought it would be a simple and a straightforward application. But now, seeing the trajectory it has taken, he has raised an avalanche of issues for which we would require them reduced in a particular format so that we can seek instructions from our client.
In an affidavit.
So we're seeking that we get a formal thing that will enable us to seek instructions.
Remind me your name.
Dr. Kamodo.
Dr. Kamodo, for the 10th respondent.
Your Lordship, I am making an application on the basis of the law. Your Lordship, if it is not crucial for us to have an IBC to confirm whether Professor Kithure Kindiki is a registered voter, that will mean, Your Lordship, that a person can go to Mathare Hospital and designate a person to become a deputy president. The qualifications created by the Constitution have a mechanism of being established, Your Lordship. And the process of establishing those qualifications, Your Lordship, is set down and out in law. Your Lordship.
Mr. Njiro, my understanding, when you first asked for this conservative order under Madu paper,
yes, sir.
it was...
That is his application.
Yeah.
I have on a different application. I moved under
because my understanding is that if you want the court to give conservatory orders immediately after rendering a ruling or a judgment, that application can be verbal but also very short, because the court is already aware, has already expressed itself.
That's correct.
So that kind of application cannot be the beginning of another big application.
I am well guided.
So I think for the purposes of the discretion of the bench, for the purposes of the discretion of the bench,
yes,
I think Mr. Ochieng's application is what we should be considered. Your application evidently requires to be formal.
Your Lordship, I am well guided by the court, but the court also needs to perhaps appreciate the import of Rule 24. That due to the vulnerability of the rights and the vulnerability of the infringement and violation of the Constitution, I can appear before you.
Rights cannot be vulnerable. Individuals are.
May I have my time and then have your response, Professor? Your Lordship, this application is premised again on Article 3. The call upon every person to protect the Constitution. And as I pen off, it is all clear to us that nobody can deny, not this court, not myself, nobody can bury his head under the sand, that there is no IBC. If Kithure Kindiki is to be sworn in tomorrow, what will be the import of swearing in a person who has not been verified and approved by the organ that is supposed to do so? Finally, Your Lordship, can this court fold its hands and watch and midwife and babysit a violation of the Constitution? What is the role of the court when it comes to the issue of Article 3 of the Constitution and the question of the sovereignty of the people? Your Lordship, I beg that you hear us. I beg that you grant the conservatory order staying the swearing in of Professor Kithure Kindiki on the basis that he has not qualified to hold that office. Secondly, on the basis that his purported qualification has not been verified by the body that is mandated to do so. In the absence of that, Your Lordship, you will be inviting us to say that even an insane person can become deputy president, a bankrupt person can become deputy president. I rest my case.
Lord, let me respond to...
So that Professor Ojenda and every other counsel who is seated, please sit down. We have two applications, and this is not going to be a start of another court process. It's not going to be a start of another court process. The applications which have been made are discretional. So I'll only allow one response, and then we'll render a ruling. Only one response.
Yep, my Lord, if I may respond, my Lord. My Lord, you made a ruling.
Okay. Okay, let me hear two people from this side. And two people.
You're one person.
Dr. Kaminwa, please say what you want to say and be mindful of time, please.
Yeah, I want to take my time. Justice Eric Obola, Justice Andrew Murima, and this Justice Frida Uganzi. I've listened to what you have said very carefully. And from my point of view, one of the interested in developing the goodness of the country. You have done, you have developed. But there is one thing I would like to point out to you very first. That we are operating in very dangerous waters. from Cairo. And this is an area where we have to call for wisdom. We have to call for deeper understanding of human nature and for deeper understanding of the society in which we live in Kenya. And what I'm saying to you is reflected in my broad reading of the authorities indicated in the United States of America. If I may say so with respect, perhaps more than anybody else, when I was engaged to get involved in this case, I ordered for a book from India straight about the electoral report on impeachment. And I've taken the trouble to read them day and night. And one thing that has emerged from all these authorities when I was reading them very carefully is that the court in the United States have continued to think very carefully how will this judgment be received by the people, by the consumers. How will it be received? Is it a judgment that will continue to promote stability in the country? Is it a judgment that will continue to promote the rule of law? Is it a judgment or ruling will continue to promote stability in the country? And it's here that I'm inviting you very respectfully that you consider the able remarks of my learned friend, Mr. that we should not, and my friend,
Only it's one-sided.
we should not ignore what they are saying back here.
But it looks good.
With all respect,
I finished it up.
we don't want to move out of this court.
Then I'm going to take it
And then all of a sudden we are told that we are protest now in second. I'm not trying to
Just hold on.
all that I'm saying to you, you're not
Sorry, my lords. The utterances by the Honorable Dr. Hamino, Council, are. I'm giving you the title, sir.
No, what I'm saying, let me say what I'm
Unfortunately, they're insightful, they are trying to preempt matters that are not before this court. We do not know and we cannot speculate that anyone is going to be happy or unhappy about it. The sword of justice cuts both ways. There are those who are going to be happy, there are those who are going to be unhappy. That is how life is, but you cannot incite by saying from here, we will have protests, we will have what? We do not know of that. And unfortunately, my lords, I ask you to kindly restrain him from taking that route.
With your kind permission, Your Honor. Sorry.
We want you to know that we have rendered ourselves in this matter. We have rendered ourselves in this matter. And we are not going to open this matter for a further court proceeding. There are two applications before the court, one by Dedlo Chieng and one by Ndegwa. After Dr. Kamuna has spoken, we'll allow two people to respond and then we'll make a ruling.
Thank you.
I thought I was also you indicated we have two people and I was prepared kindly to make an application.
Continue, Dr. Kamuna.
You know, my Lord, I'm actually, it's only one sentence. When you read the book, I have referred to authorities in America. The judges have made a finding along this line. Yes, this is a people. So and so is people. But we shall not go ahead with that. We shall be held. So that's all I'm saying to you. You have come up with a very family society, a ruling full of students, and particularly my Lord Gachagua has come up with something that I had not thought of. very much at all. But all I'm saying to you that you agree, but you still have the discretion to say that, look, we are not, we have these are our findings, but still we are going ahead to give conservative orders for so many days or so many weeks. So you still have that discretion for the sake of the country.
My Lord, may I kindly, my name is Sam Meberi. I appear for the 9th petitioner in the second cohort. My Lord, I stand to make an application for stay of the orders that have been issued this afternoon relating to the application that was before you, and having keenly listened and internalized the import of that ruling or order, my Lord, we wish to move the court, much as we have that opportunity by way of the orders that were given, that we were given right to appeal, that pending the appeal, pending the lodging of the appeal, my Lord and my lady, you allow us that opportunity of stay so that we can ventilate our issues before the appellate court. My Lord, what informs this application is that there is an apparent risk by the fill-up of the position of the Deputy President, and in our petition we had named the Professor Kibura Kindiki as a party in the petition that we had filed for the 9th petitioners. So that, my Lord, having analyzed and internalized that, we feel that the petition, in the fullness of time when the court is going to process it, we will be dealing with an issue that perhaps will compromise the rights of the 9th petitioner who has moved the court. And, my Lord, the other issue is that there is a period within which the respondents, if they have to move, they have to fill up that position of the Deputy President. So that, my Lord, there is no any prejudice that will be occasioned to the second respondent if the orders of stay gets issued, because by close of business today, my Lord, we are going to lodge the notice, and that notice by itself acts as an appeal, and in the fullness of time we shall be processing the application before the appellate court for appropriate orders to issue. My Lord, I therefore associate myself with my colleagues on the application for stay so that we don't have the proceedings before you in the fullness of time when we come to canvass the petition to be rendered nugatory or academic. My Lord, you have the discretion, and we ask and beseech you to exercise that discretion in the favor of the 9th petition. Thank you, my Lord.
My Lord, I would like to make an application under Article 1.1 directly. And my lady. My lords and my lady, we are thankful for your ruling today and the lengthy explanations and court case that has gone into it. Unfortunately, my lords and my lady, it seems that some people are being favored over us, and in this matter, it is the state or advocates. We are here acting in person, and we are entitled to the same equal protection of the law. We are here trying to defend the Constitution and our constitutional rights. I am being discriminated against as a woman, as a person with disabilities, and as a youth, my lords and my lady. We filed our application on the 8th of October 2024, and we thought that we would be enjoined as interested parties to participate in Tuesday's proceedings, but we were not. So we did not have the time to ventilate our issues properly. My lords and my lady, we are asking you to stay your orders for 7 days, as you have told us to come back on the 7th of November, so at least we get a fair chance, a fair fighting chance as a sovereign to also ventilate our issues properly. The state cannot override us, and advocates cannot override us, my lords and my lady. This is a court for equality, and we are asking for equality. My lords and my lady, we also appreciate that regardless side has asked for 7 days to appeal. Kindly consider us in, because there is no point in justice. It will be granted to some petitioners and others will just be thrown under the bus and into the darkness. Thank you.
final respond.
Can you just clarify, your application says dated the 8th of October?
8th of October 2024. It's petition E541 of 2024, who was seeking stay orders to stay the proceedings in the National Assembly based on Article 32(1), freedom of conscience, and Article 33, freedom of expression.
Maybe with your kind permission.
Let me clarify. Is that the matter in which we are dealing with Dr. Bosso?
Yes, my lord.
Yes. Now, if you have been following the directions of this court keenly, we have been issuing various orders on consolidation. And I can assure you, I did that. And you and Dr. Bosso are petitioners in one of the cohorts. I think it's cohort number 1. Yes, it's cohort number 1. You're petitioners in cohort number 1. And we directed everybody to get into the CTS system. And whoever has a problem to get in touch with the deputy registrar. So it is not right, Ms. Wanjiru, to claim that you have not been enjoined in this proceedings. You have been enjoined, you are a party, and that is why we allowed Dr. Bosso to address the court, even yourself.
Yeah,
So you are a party. You are a party. That one I can assure you.
My lords, we were not entitled to the right of enjoinder, and we had points that we wanted to defend against the respondent's side. So we're just finding it very difficult that due process is not being followed in our instance, as we applied even before both parties on the 8th of October 2024. They came to court on the 18th, 10 days after us, and they have still been granted audience before us, and we were told we're going to be in cohort 1, and then cohort 1, this application has already overtaken cohort 1. We're now being told to come next week after the swearing in would have been gone through and after numerous rights would have been violated that we have raised.
I think, Ms. Wanjiru, what you just need to do is just get into the CTS, get all the directions. There's every direction. There's a reason why we came up with cohort 1 application petitions and cohort 2 applications.
Yes, my lord.
So I think we may not wish to respond on whether you are discriminated or not, but we're so sure you are not discriminated because there are proper directions in respect of every cohort and every matter before us. Kindly take time to go through the CTS.
My lord, I offer to assist.
Thank you. This court had made directions on this issue. Yeah. We said there are only 2 applications before this court right now, and those are 2 applications which will be responded to. We have applications, we are finished with this side.
You have not spoken